Hi, I'm Nick Nicholson. I head up the Insolvency Department here at CIBLS. I'm here today to talk to you about the new Corporate Insolvency and Governance Act 2020. This new law has been introduced to address the limitations in the current insolvency regime to quickly and efficiently deal with the huge amounts of debt accrued by otherwise viable businesses as a result of COVID restrictions, namely the deferment of taxes, VAT and PAYE, CIBLS loans, bounce back loans, and rent that won't have been paid for at least half a year. At the moment, the insolvency profession wait to see how the new legislation will work in practice. It is a complex area, and the different treatment of pre-moratorium and post-moratorium debts is something for another day. The key headlines of the Act are: it introduces a moratorium preventing creditors from seeking to take action to enforce their debts during the period of the moratorium without the court's permission. The moratorium initially lasts for 20 days. It can be extended quite easily to 40 days, and with creditors' permission to a year, and potentially with the court's permission indefinitely. The directors remain in control of the business and its trading during the period of the moratorium. This is a major difference from the current insolvency regime. The Act introduces a new role for insolvency practitioners, that of monitor. Before the moratorium can be entered into, the monitor has to form the view that it is likely a moratorium would result in the rescue of the company, as opposed to the business, as a going concern. How the monitor is able to form that view is currently up in the air. The monitor continues to check on the company's trading during the moratorium and is able to terminate it if he considers it is no longer likely that the company can be rescued. So in essence, in that period, a deal has to be done with creditors to ensure the company can exit moratorium and continue to trade. Another key aspect of the Act that has hit the headlines is the suspension of personal liability from wrongful trading. In essence, as it currently stands, a director can be held responsible for the increase in liabilities accrued by a company after a point in time when it is determined he ought to have known that the company could not avoid insolvent liquidation. Given the obvious current uncertainty as to future trading conditions, the Act absolves the director from any liability for liabilities accrued during the COVID crisis and currently puts an end date on that period of 30th of September 2020. This does not absolve directors from other duties owed to the company or for fraudulent trading. Obviously, the purchase of a boat with a bounce back loan will be one such breach of duty that could be enforced at a later date should the company fail. It is also worth noting that the legislation prevents creditor action to wind up a company during COVID, with the prevention of petitions being heard and statutory demands being enforced until the 30th of September. It is likely that we will start to see widespread use of the new procedures when creditors and landlords can actually take action to enforce debts. As I said at the outset, this is a complex new area of insolvency legislation and procedure, and I will be more than happy to explain any area of it to you in greater detail.